All right, how's your toe?
It's missing.
Oh, it's gone.
Yeah, they amputated it.
So, in Stripes, Bill Murray said the big toe was the captain of the toes. So at least it wasn't the captain. I hope you're doing better.
Concerned about witnesses watching YouTube. I'm
Mhm.
concerned with potential jurors watching YouTube or asking friends or family to watch it.
All right, so that motion is denied. What's your next motion?
I would respectfully ask the court to recuse. And then the motion was a motion to recuse
Okay,
on that.
oh,
So
that's fine. Oh, counsel, you can file whatever motion you want to file.
as I mentioned in the beginning, we have started talking about possible resolutions to the case. And
Yes, Your Honor, I grabbed her arm.
All right. And I'm assuming the grabbing of the arm caused pain. Is that correct?
yes,
All right, how's your toe?
It's missing.
Oh, it's gone.
Yeah, they amputated it.
So was it the pinky? Oh, so was it the pinky toe or the big toe?
The smallest one.
All right. In Stripes, Bill Murray said the big toe was the captain of the toes. So at least it wasn't the captain. I hope you're doing better.
It's human.
Okay. So, Mr. Sharp, have you received all the discovery in this case?
believe we have.
All right, so I'm gonna need a discovery acknowledgement done. And let me see where we are on the docket. Brenda, do you see Mr. Diller? All right, thank you. All right, so has an offer been tendered?
Yes, Judge.
And when was the offer tendered? Oh, I see it was tendered on September 13th.
That sounds right.
Okay, so Mr. Diller, have you had ample time to consider the state's offer? Are you rejecting the offer? All right, so your plea deadline date has expired. Ms. Ferguson, can we get a jury trial date for Mr. Diller?
Yes.
And your jury trial date will be sometime in the new year. We do have a capital murder case that's upcoming, and it's probably going to take us into mid-December. Unless your attorney wants to be here on Christmas to try.
I can do January 10th.
Okay,
If
I'm
you'll
taking,
be here, Judge, I'll be here.
oh, he says
We'll
that.
bring the whole family.
Oh, well, let's do it. He says that, but then if we're here, he's like, Judge, I didn't know you were serious. So you say January 10th? All right, so it's going to be January 10th. Who would have thought we're now saying 2023?
All right.
You need to be here at 9 a.m. dressed for trial. A jury will be here and we will start your jury trial. All right.
Is that a special setting like with that?
I don't do special settings.
It's on the docket with everything else.
Yes.
except for trial, but we
Yes.
need to be ready just in case.
Yes. So, Mr. Diller, after today, if you decide to enter a plea, the court will not accept any plea bargain agreements without good cause otherwise. And then after Diller, it'll be Cundiff. All right. So you've conferred with the new prosecutor
Yes, Judge, we have.
and I'm going to give you your jury trial date and your plea deadline date at the same time. The court does have the acknowledgement of discovery in the file.
There's
Is
been new
There is
discovery
new discovery.
all right. What is the new discovery?
discs.
The victim was out in Amarillo and gave a new forensic interview.
Okay. Do you have access to that?
Yes, it's been disclosed for about a month now, but I don't believe defense counsel has had time to review it.
I remember getting notice of disclosure, but I'm not going to argue with
Yes.
you.
Okay.
I'm
So-
remembering December 5th right now.
So how long are you all anticipating this trial?
Just a week.
Are there videos? And how long are they?
I don't believe nothing that
Is
we've
it
seen.
okay? Is it under 6 hours?
Yes.
Okay.
Yes.
So Ms. Ferguson, I need a jury trial date. They say a week, I believe 3 days.
I think 3 days is probably.
All right, we'll see you on Valentine's Day. just get a reset form from Ms. Ferguson.
Thank you.
All right. And if you all can make sure that new discovery acknowledgement is signed
Yes.
when you have that.
I just needed to approach the court. I have just conferring with the Assistant District Attorney. I had previously spoken this morning to Anna.
Mhm.
We are set on the 16th for a jury trial.
Yes.
And we were set earlier in January and the court set it for the 16th.
Yes.
Well, back in October, had a felony case in Comal County that was set for trial on the exact same day, January 16th.
Mhm.
But they make you come the Tuesday before, which was a couple days ago.
Yes.
And then I received an email from them
Mhm.
that I have to be there on Tuesday by 9:45, ready to go to trial on that case. And so I had that setting prior. I mean, that case was set prior to when the setting was changed to the 16th. So I'm just looking for court's guidance. Do I go there? Do I tell them I can't go there?
Well, is that case in Comal County a felony?
Yes, it's a felony drug case.
All right. And how long has that case been set?
It's,
I mean, how old is that case? Because we've been trying to get a jury trial done on this.
you're right, Judge. You're right. I believe that the case, certainly the offense date for the 187th case is many, many years before this guy's case.
So what we will do is this will be set in this court on January 16th. And if you need us to, we'll call Comal County and let them know that you're here. So we will put you under the umbrella of the 187th and it will be fine.
Okay.
Yeah.
That's fair.
Sure. All right.
Thank you, Your Honor.
You're welcome.
Now have a great day.
All right. I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pretrial
Sure.
motions to bring those up.
Yes.
All right, Judge. So I had filed a motion back in August of 2023, a motion to prohibit the YouTube broadcast of
Mhm.
all the legal proceedings.
Mhm.
Um,
And I don't have that motion. It's not in the court's file. We're going on the record in 2022 CR 5802, State of Texas versus Philip Diller. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Dillon.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Okay.
But just for example,
Mhm.
that was a main witness and she admitted to watching YouTube.
Mhm.
I'm concerned about witnesses watching YouTube. I'm
Mhm.
concerned with potential jurors watching YouTube or asking friends or family to watch it for them.
Mhm.
And so I'm just really concerned that Mr. Diller won't get a fair trial with this being broadcast all over the internet.
All right.
Now,
And would
I
you want the media excused as well?
Usually the media doesn't video record
Yes, they do.
out of when the jury's out of the courtroom. Like for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it.
Mhm.
I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out
Mhm.
when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay,
I don't have an objection to that. It's just broadcasting everything that happens in the case.
all right.
The reasons that, and I will, in the motion on page 2,
Mhm.
paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor. And under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy, and that by broadcasting it, her name will be revealed.
Mhm.
And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
Mhm. All right, is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Dillard getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay,
And that's just too huge a risk.
all right, and this is your only pretrial motion?
No,
All right, so that motion is denied. What's your next motion?
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay,
on this case.
sure. We'll have a hearing on that,
Okay.
and that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right,
Okay, and then the motion was a motion to recuse
okay,
on that.
oh,
So
that's fine. Oh, counsel, you can file whatever motion you want to file.
Okay.
All right, and see if you can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right, you may want that heard because technically you have not filed the motion to recuse yet.
Right, you are right.
So,
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
well, either you need to file it now. If you don't file it now, then we will hear other motions.
All right. Original 3 copies.
All right, and Ms. Ferguson, see if Judge Hall is available to hear that today, and we will be coming back here on the 17th for trial.
Oh, wait, today or tomorrow morning?
Let's see if we can hear it today or either early tomorrow morning.
Okay,
All right, thank you.
thank you, Judge.
You're welcome. Raymond Alejandro.
No, just.
Is calling 2022 CR 5802, State of Texas versus Philip Stephen Diller. Can our parties announce for the record for the state?
Second for the state, Your Honor.
Defense?
Alex Shar for Mr. Dillard.
And are you Mr. Diller?
Yes, Your Honor.
All right, the court is in receipt for a motion for continuance from the defense. State, have you had a chance to review the motion for continuance?
Have, Your Honor.
All right, defense court will hear your motion.
Thank you, Your Honor. Well, I don't believe the state has an objection to it. And there's been some plea negotiations, but in reference to him being set for trial today is the last time we were set at the week before the March 25th. We could have gone to trial then. I know you were in trial. And as soon as we got the new court date for
Just one
today,
second. Everyone in the box, please whisper. Yes, you may continue.
And so when I let Mr. Diller know, his wife chimed in immediately, I cannot be there the April 8th through the 10th. She'll be back from a conference that's mandatory for her employer, which is Southwest Research. She'll be back tomorrow, probably late in the afternoon. What's that? 8 p.m. tomorrow.
Okay.
But she's a crucial defense witness. In the motion, I outlined what I expect her testimony to be. I have interviewed her. And I have also attached an affidavit that details what her expected testimony is. She is a crucial witness for the defense.
All right. So here's my thing. You're saying she'll be back on tomorrow by 9 p.m.?
Yes, that's
All right.
expected.
So we would do jury selection. If your case is going, we'd do jury selection today. And I don't think the state is going to finish with their case, or they may be finished with their case in one day on Wednesday, but she probably will not need to be here till Thursday.
Then, I mean, then that would obviate. the need
All right.
to
So there's no
reset.
need for the motion for continuance.
Well, if the court is going to work around the schedule,
I mean, if you're telling me that she will be back on April 9th,
be back to 10.
the 10th, if she'll be back on the 10th by 9 p.m., if her testimony is needed, it will be needed at the earliest on the 11th. So there's no need for a motion for continuance? Is that correct?
Well, I mean, I'm not, I'm just saying she can't, if she wasn't here yesterday, she can't be here today, and she won't be here till tomorrow night.
Well, it appears that her testimony is not going to be needed if you wish to call her until April 11th. So are you withdrawing your motion for continuance?
No, Judge, as I mentioned in the beginning, we have started talking about possible resolutions to the case. And broached this subject with him, but I really need her here to discuss things with her too, since they're married.
Well, I
and they
think
have a
you all
child.
better get on the phone, because if you still want to proceed on this motion for continuance for these reasons, the motion for continuance is denied. So y'all need to pick on the phone and call her if that's what you all want to do.
So then when would you want us back to start jury selection?
Oh, jury selection is going to happen this afternoon.
Okay.
Mhm.
So at 1:30.
Oh, as soon as everyone finishes conferring. So motion for continuance is denied. And if you want to speak to your wife, I suggest you all call her on the phone, because once this jury trial starts, it's starting. It's not stopping in the middle of trial, because you all have worked something out. Is there anything else?
Not at this moment.
All right, thank you. Trinian Stidham. All right, we're going to go on the record. Court is calling 2023 CR 5802, State of Texas versus Philip Diller. Can I have parties announced for the record for the state
That done for the state, Your Honor.
defense?
Alex Sharf and Mr. Diller, ready?
All right, and are you Mr. Diller?
Yes, Your Honor.
Counsel, have you received all the discovery, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Diller, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Off the record for a moment. Counsel in the box. Excuse me, sir, in the box. If you will speak with the deputy, they'll move you down to that end. All right, we're back on the record. Mr. Diller, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on the lesser included injury to a child.
Any objection?
No objection.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of injury to a child, bodily injury intentionally or knowingly? That's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Diller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of injury to a child. They're recommending deferred adjudication and there's to be no contact with the complainant. Did you understand that to
Yes,
be
Your
the
Honor.
plea?
Yes, Your Honor.
Defense,
Yes, Judge.
state?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yes, Your Honor. State offers states 1 and attachments.
Any objection?
No objection.
All right. And state, is the complainant aware of this agreement?
They are, Your Honor.
All right. You may continue to
Thank you,
confirm.
Judge.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. We're back on the record. The court has considered states exhibits 1 and attachments, which includes the stipulations. Is there any other evidence either side wish to present to the court before the court makes a ruling on sufficiency of the evidence?
Yes, Judge. Mr. Diller would like to make a brief statement.
All right. Yes, Mr. Diller.
Yes, Your Honor. I grabbed her arm.
All right. And I'm assuming the grabbing of the arm caused pain. Is that correct?
Yes.
All right. Is that yes?
Yes, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this is a life-changing incident. Mr. Diller also suffered from a very debilitating accident in 2019. Prior to the outcry, before the charges were filed, he's in a great relationship, and he's been frozen in fear about fighting this case, and he would do it if he had to. This plea agreement, we believe, is in the interest of all the parties. Mr. Diller will not have contact with the complainant in the future.
Okay. Are you employed?
No, Your Honor.
So how do you support yourself? Are you on SSI or something?
I filed for the, I got denied for the original one because I have too many resources available to me because of my wife's income. Now they're doing the disability part of it, and I think they're at 95% right now.
All right. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with the complainant. All right, I understand that you have some medical issues that may preclude you from employment. The court costs in this case is probably going to be around $385 to $400. So if there's a reason why you cannot pay that, just let probation know, and they'll have to do an indigency form for you to see if that's true and if it would be appropriate for that to be waived. Do you understand?
Yes, sir.
Do you have any questions about anything?
No.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to court. All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Great day.
You too.
Today, we bring you the story that helped spark the fire against Judge Boyd. It started like any other case until the internet got involved, and the courtroom would never be the same. It was just a routine plea hearing. A man charged, lawyers present, and a deal on the table. 15 years. Everything was moving normally.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of aggravated? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr. Villamil, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had a chance to confer with an immigration attorney?
I have conferred with an immigration attorney. I have informed him that a plea to this is, he's actually a permanent resident. A plea to this would be a certain denial of future permanent residency and deportation after serving a prison sentence, which is what he's pleading to.
All right. Mr. Vial, did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of entering a plea in this case as it relates to your immigration status?
Yes, Your Honor.
All right. Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, you're pleading on count 3. Punishment is to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's Chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this
Yeah.
complainant his relative or not?
Yes.
Okay.
Yes.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
Yes.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea,
And we offer State's Exhibit number 1 and all attachments.
Okay.
showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will find you guilty. Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of he has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept
Your
this
Honor,
agreement?
Your Honor, that is very young. She's in therapy right now. I discussed it with the mother.
Here's the moment where everything changed. As the case played out live on YouTube, comments started rolling in. Angry, emotional, demanding more time. Judge Boyd noticed and her look changed.
By bringing her in and talking to her about this case.
This case is horrible. And I mean, I know he says he's pleading to a one-time, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal
Yeah.
issues with that. So,
but I mean, having her brother lick his,
that was something that I think was determined that did not happen.
well, she says that he asked her to lick his,
That's a different one. Yes.
what is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her, and that's.
And you got turned on.
No, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean? Like,
So you blaming a 6-year-old?
I'm not blaming my 6
Your
year
Honor, if I
old.
may, my client was sexual when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously it's not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will.
So
have to
he's
live
being released after he does his time, released to go somewhere else and deal with his trauma that may result in him some other.
Well, he has, what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that to do that. We have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And And, you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which
And
I
what
understand.
country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point, what were you thinking?
Yeah. I can just say sorry, but like, the only thing I can tell you is that I didn't like, I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by anus with his finger. And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in. And as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up. And he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 75-85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you, and now that he has done it, and what
No, he pled no contest.
he pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah, so I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried, I'm begging and telling you, please, I'm telling you, please. I'm not trying to force my hand in her. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't, I don't know how to
No,
explain
so
it.
the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally.
the thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole, but like at least 4 or 5 times, dropping her pants. Like, literally, like it's not like I'm telling you like my actions were right.
I know, I'm just trying to figure out where you are mentally and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time he told police officers that he had put his finger inside of her.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has deviancy, and it's obvious, but all of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right, so this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother And the benefit of the child is to get this done, have no right to appeal, so the child on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right, if you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
Or, all right.
Your Honor, two things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow.
And if I'm in jury trial
Oh, tell 13, you need to be here tomorrow.
and have her jury wait.
Yes. This is district court. So I'll see you all tomorrow.
What happened next? The defense argued Judge Boyd was influenced by public opinion. A new judge was assigned, and this became one of the first cases that ignited the controversy. What do you think? Did live streaming help or hurt justice? Was it fair for the court to react to the public? Personally, this is why I love Judge Boyd. She doesn't just sit on the bench, she listens to the people. She feels the moment. Not everyone agrees, and that's okay. So I want to hear from you. Drop your opinion in the comments below, and don't forget to like and subscribe for more courtroom stories.